We're going to take a quick look at witness slips. We have 300 on the amendment. We have 307 indicated as no position. We have 36,867 opponents and 271 proponents. I'm sure we'll all understand we are not going to read those into the record right now. Representative, if you would like to make an opening, oh, I'm sorry. I had forgotten. I have also received another letter from Speaker Welch. We are replacing permanent member Representative Hirschauer with temporary member Representative Costa Howard. Clerk, if you could please just update that in our roll. Representative, if you would like to present changes in the amendment.
Thank you, Chair Mussman. Today I'm just going to highlight a few because I'm sure we have lots of questions, and in the interest of time, I'm going to just give a few of the highlights for House Floor Amendment number 2 for House Bill 2827. The amendment addresses some of the issues and concerns that were raised by both proponents and opponents to the bill. For example, we've rewritten the findings from the original bill. We have tightened language regarding definitions such as educational portfolio, and again, changed some language regarding adequate education. We have made changes to the declaration notification form. It also, in addition to removing some language that stated not limited to, so it's very prescriptive about what information will need to complete that form. But we also made the change of that form being submitted both online or in person to our regional office education or the intermediate service center, and not directly to the school district. We have also in section 55 clarified educational portfolio as part of the investigation for 10 business days. And at the request of the non-public schools, we have changed, I believe it might be on page 23, regarding the private schools, and we accepted their suggested language regarding not having to provide a full list, but only to either confirm or deny whether a named student is enrolled or attending. Those are some of the highlights, and I am prepared. I know we have 2 witnesses, 1 for each side, and then I will answer any questions. Thank you.
Thank you. Is there a preference for how we go in order? I believe that we have Carmen Longoria Green on behalf of the Coalition for Responsible Home Education on Zoom. Carmen, if you would like to take yourself off mute, state your name for the record, and proceed with your statement.
Yes, thank you. My name is Carmen Longoria Green. I am the board chair for the Coalition for Responsible Home Education, or CRHE. We are the only organization in the country founded and run by people who were actually homeschooled, and we exist to advocate for changes to the law to protect homeschooled kids. I'm here to urge the committee to vote yes on HB 2827. There is an urgent need to ensure that homeschooled children in Illinois are safe and are being educated. Illinois trails the country in terms of its homeschooling laws. In terms of protections for kids, Illinois' peer states are Texas, Oklahoma, and Idaho. And this lack of protections results in serious harm to kids. There's Alexandra Bethard, who was homeschooled in Illinois and, in her words, never received a formal education. Instead, her days were spent cooking, cleaning, and essentially being a second mom to her younger siblings. There's Whitney Harrison, who was homeschooled in Illinois from 3rd through 8th grade. When she finally got into a public high school, she had the equivalent of a 3rd grade math education. And there's Casey Pickett. She was homeschooled in Illinois by parents who believed that women did not need to be educated to the same extent as men. They told her too much knowledge isn't good for a female's brain. So they denied her access to higher level math and other subjects that she would need if she ever wanted to go to college. These stories are not unique. I can tell you, as someone who has homeschooled myself for 12 years, just next door in Missouri, that when there are no legal protections in place, which is the case in Illinois, there is no floor for how bad the homeschooling experience can be. And that reality is borne out by common sense. Think of the most irresponsible person you know, or the most unstable, or just someone who's just not able to do a follow through. Daily, grueling dedication to their child's education. Some people can do it and do it well. I have seen it. But it's just as true that many people can't, even if they have the best of intentions. That's simply a fact. And on top of that, it is also a fact that some parents don't have good intentions at all. Some parents use homeschooling as a facade, a disguise, to hide their children from the teachers, coaches, other students, and other parents that their children would encounter in school. CRHE maintains a database called Homeschooling's Invisible Children, where we track cases of severe abuse and neglect in homeschool settings. We have documented hundreds of these cases, including cases in Illinois. In fact, ProPublica published an article just last year describing how Illinois' lax homeschooling laws allow parents who have nefarious intent to hide their crimes. It is a fact that Illinois children have died because there is no mechanism in place under current law to make sure that a child is removed from school to actually homeschool them, not just to hide them. Homeschool laws should not be built on the fantasy that every single parent is a good parent. Everyone in this room knows that isn't true. We only need to turn on the evening news to see the type of child abuse and neglect that adults are capable of committing. It is time for Illinois law to reflect the reality of homeschooled kids' lived experiences. That reality is that homeschooled kids can be abused and they can be educationally neglected. The law should have a response to that. HB2827 rises to this occasion. You have heard, I know, from many homeschooling parents who tell you that the sky is falling with this bill. Homeschooling in Illinois will be gutted, according to them, but that is false. More than that, that's a narrative being pushed by a multi-million-dollar lobbying group that makes its money by frightening homeschooling parents into thinking that homeschooling is about to be banned at every turn. The reality is that HB 2827 still leaves homeschooling in Illinois less regulated than it is in incredibly pro-homeschooling states like Florida, Georgia, Carolinas, and Louisiana. After HB 2827 is passed, homeschooling in Illinois will still be less regulated than it is in those states. And HB 2827 puts in place common sense changes. First, parents will have to notify the ROE once a year, let them know that they're going to be homeschooling their child that year. This notification requirement is found in 38 other states. Second, parents will need to maintain a portfolio. I was homeschooled in Missouri, and that state has a portfolio requirement just like this one. I can tell you from my personal experience that this legal requirement ensured that my parents and others kept a log of their children's education, and it ensured lesson planning throughout the school year that would not otherwise have happened actually took place. Second, this portfolio is critical to ensure that there is a material on hand for determining whether a child is being educationally neglected. This is a practical, common sense requirement that other states have adopted. And third, the current version of the bill lays out precisely how a truancy officer will carry out an investigation into educational neglect in a homeschool setting. There is currently a gaping loophole in Illinois law. If someone calls in with a concern that a child who is purportedly being homeschooled actually isn't receiving an education, there is no mechanism in place to respond. The fact is that a parent claiming to homeschool can just say, I'm homeschooling, and slam the door in the truancy officer's face, and nothing further is going to be done to check in on whether that child's receiving an education. I cannot begin to tell you how many times I've heard from people who were homeschooled as kids about how they thought, finally, things are going to change. Things are going to get better because a family member, or an older, now adult sibling had contacted the authorities about the educational neglect that was happening. All for, in the end, nothing to happen at all. This aspect of Illinois law must change. There needs to be a process in place, spelled out in the law, for how to handle reports of educational neglect in a homeschool setting. HB 2827 brightly creates this process. On top of that, CRHE has determined through its research that educational neglect in a homeschool setting is often comorbid with other forms of abuse and neglect. This means that, in addition to uncovering educational neglect, the process set up by HB 2827 will also help identify other forms of physical abuse and neglect in a homeschool setting. And that's critical. Homeschooled students are unique in that they are not seen by the teachers, coaches, other students, and other parents that they would encounter in school. So the primary mechanism that our society uses for identifying cases of child abuse, which is namely, we trust our mandatory reporters and other adults in a child's life to say something if they see something. That mechanism doesn't exist for homeschool kids if their parents decide to isolate them. So it is important for there to be a mechanism in place, again, spelled out in the law, for identifying abuse and neglect in homeschool setting. I am a homeschool alum. I was homeschooled for 12 years. I am speaking on behalf of the thousands of homeschool alumni that CRHE represents. The modern homeschooling movement is now almost 40 years old. And the products of that movement, homeschool alumni like myself, well, we've grown up now, and we're able to tell you what it is actually like to be homeschooled. And we can tell you the good, the bad, and the ugly. And we are begging you to listen to us. We are telling you there is a problem with current law, and that problem needs to be fixed. HB2827 rises to the occasion and addresses serious gaps in Illinois law. I urge you to vote yes on HB2827. Thank you.
Thank you for your testimony. Ms. Butler? If you would like to approach the table, state your name for the record, and then go ahead and proceed with your testimony.
So my name is Pastor Chris Butler, and we were both hoping to address the committee, but we're told that only one of us would be able to. And so I won or lost the coin toss, however we want to look at that. So I give you my greeting and good morning to the chair and to all the distinguished members of this committee. I am Pastor Chris Butler. I am a homeschool dad of 6. I am the senior pastor of Ambassador Church, serving the city of Chicago and the South Suburban community of South Holland. And perhaps most luckily, I get to be the husband of the incredible woman sitting next to me, Aziza Butler. I'm here today to voice my strong opposition to House Bill 2827 and its proposed amendment number 002. The last time I got a chance to sit in this committee room, this incredible woman next to me, Aziza, sat before this committee and raised concerns about the bill seeing grow up in my church and in the communities that I serve. And it is about this movement that I particularly want to speak to this committee today. This movement is not 40 years old. This movement does not have million-dollar organizations behind it. This movement is a grassroots movement of people desperate to save their children from schools and a school system that has failed a generation. I am here today as somebody who grew up in Chicago public schools. I am here today sitting next to somebody who taught in Chicago's public schools, and we too have grown up, and we too have something to say about the education that we received, and it is why people in our generation have stepped up and said we must do something different. I'm here today because, as amended, this bill still concerns me where that movement is concerned. Under Amendment number 002, Section 30 creates a rebuttable presumption that homeschool students are not truant if and only if a homeschool notification form was submitted. This still leaves parents, in my opinion, subject to Illinois' problematic criminal truancy laws if the form is not filed. And again, we serve the community of people who will not hear about this from the existing homeschool listserv, and there is no money in this bill to educate our communities that they are even subject to these rules. In another place throughout the bill, the threats of immediate criminal penalties have been replaced with truancy investigations and referrals to the state's attorney's office. I do not need to tell the distinguished members of this committee that the state's attorney's office is a criminal prosecutor. replacing criminal penalties with criminal referrals is little comfort to that single mother on the south side of Chicago who has seen in homeschooling a glimmer of hope for her child, but wonders if the public system that has been funded to fail her precious little one is going to freely give him up without a fight. Amendment 002 contains new language that to me is deeply concerning. You'll find these words on page 40 of the amendment. Quote, the truant officer or county truant officer notified of a homeschool violation of section 30 of the Homeschool Act shall meet with the child or children complained of and make an initial determination whether there is cause to start a truancy investigation. I'll say this again. Meet with the child to determine if there is a cause. If a truancy officer can separate a minor child from his parent for a so-called meeting, is that parent not being treated like a criminal? If a truancy officer can gain entry to a family's home without a warrant, whether welcomed or unwelcomed, is that family not being treated like criminals who have forfeited their rights? There can be no doubt that this bill, as amended, still lays the groundwork for a homeschool to prison pipeline. And that is something that none of us should take lightly. But Amendment 002 goes further than that, goes further than the original bill, and that it not only attacks homeschooling families, it seeks to undermine the networks of communities and resources that support homeschoolers and help them find success. Organizations and communities like We School that my wife leads. Section 15 of the bill on page 3 creates a draconian new definition of homeschool to mean a program, quote, a program where instruction is provided in a student's home environment and which may have more than one student so long as the student in the homeschool are members of the same household. It goes further to specifically state that homeschool does not mean a group of 2 or more households who provide full-time instruction under an agreement. This definition introduces a massive amount of uncertainty and precarity around the legal status of organizations like We School and hundreds of other co-ops, micro schools, and innovative learning communities that are growing up all over our communities. Do those organizations have to become register as non-public schools? Do those parents participating in those programs lose all of their rights? Are their children considered chronically truant because they are working together to educate their children? The question here is, if this legislation is about protecting children from abusive situations, as the proponents have suggested, what is the logic of coercing families to retreat from community into their homes, retreat from spaces where they would interact with other children, with adults outside of the home, and even come in contact with mandated reporters in churches and in park districts and in other shared spaces? I continue to be schools. Some adjustments have been made, but these public schools are still being tasked with the creation, distribution, processing, and maintenance of this new form that tens of thousands of families will be bringing. The district is also charged to perform portfolio assessment. Now, I'm somebody who, in the early part of my career, spent a long time trying to move us away from standardized testing to portfolio-style assessment, but we have no robust system in place to do portfolio-style assessment. There is no new funding allotted in this bill to support our public school system in taking on these responsibilities. But again, Amendment 2 goes further. Not only do local school districts and the State Board of Education get saddled with these new administrative responsibilities, the new amendment will add unnecessary caseloads to state's attorney's offices. If you live in Cook County like me, you would rather have the state's attorney investigating and prosecuting much more consequential crime. This will balloon the caseload at DCFS, an entity that investigative journalism has already shown is badly stressed and in crisis. This bill is different in its amended form, but it still is just as harmful to the future of education in Illinois because it is harmful to this movement that I am so passionate about. Those who support this bill have argued to us that the bill is just a form, a simple administrative process that all the rest of the states are doing. But can I point out something that Illinois is a state that is a leader on a lot of justice issues, and I think we ought to be proud of that, not ashamed. Can I point out that all of those 38 states that are pointed to, not one of them has in the last 10 years passed a single law that makes homeschooling more restrictive, and many of them are passing legislation that makes homeschooling less restricted in their states. We are not an outlier, we are a leader, and we should be proud of it. The logic that this bill is going to just be a form wants us to assume that a simple administrative process cannot harm anybody, but that logic is flawed. It is why you cannot ask somebody about their race on a mortgage application. It's just a question. It is why an employer cannot ask a female employee if she plans to become pregnant. It is why a movement has grown up all over this country to ban that little box on a job application that pre-screens for a criminal background. It's just a box. The reality is small administrative processes can be catastrophically burdensome for disadvantaged peoples. We do not want this to come into play in our state. In order to receive this bill as what it is supposed to be, we have to believe that homeschool is, in principle, a large haven for child abuse and neglect, not in some particular. There will always be anecdotes that you can tell to scaremonger about any activity on the earth, from homeschooling to riding a bike. In order to receive this bill, we have to believe in principle that homeschooling is some kind of a haven for child abuse and neglect. And while there are those who may want you to believe that, there is no evidence that this is the case, and the best evidence that we do have suggests that homeschoolers are 40% less likely to die from abuse or neglect compared to the national average. We have to believe that putting a form in place is going to compel criminal abusers and violent sociopaths to change their behavior, to come forward and file their form, to put on their form that their curriculum is not teaching little girls and abusing little boys. Listen, I'm a pastor. I've studied theology and ethics and the human condition. And my heart grieves for every little child that is abused, and my heart sympathizes with an advocate and a legislator who spent years as a vice chair of a child welfare committee. My heart sympathizes with the desire to reach for a quick fix to this kind of tragedy in our communities. But the reality is that child abuse and neglect is a large cultural problem, and it will only be solved by a large social and cultural project. There is no simple legislative solution. We would all sleep better at night if there were, and we would all gladly support a piece of legislation that could do that. But what I know about the human condition, what I believe your hearts are telling you about the human condition, is that there is no easy legislative fix. It won't fix that problem, but it will overburden homeschoolers across this state. But I'm talking to you in the particular about what I believe is the most hopeful thing that is happening in education in our state, and that is the number of parents who are stepping up to say, come hell or high water, I am going to do what it takes to secure a good and fruitful education for my child. That is happening in our state. That is happening in the city of Chicago. That is happening in the church community that I lead. And I am begging the members of this committee not to allow this bill to go forward because it will severely threaten that hopeful movement. Thank you so much for the opportunity to speak with you on today.
Chair, do you want to just go to questions, or can some of the language through the testimony, whatever you would like me to?
You go ahead and respond to some of the pertinent points. I do believe the State Board of Education is also in the room and available to respond to certain points that were brought up. We want to make sure that the record is accurate. Thank you.
Thank you. So first I want to talk about the issue of criminal truancy that was brought up. I want to make the record clear, both Virginia and Wisconsin use their truancy statute, which is the same as ours, as their enforcement mechanism. So if the issue is you don't like the way the truancy statute is working, well then we should go back and take a look at the truancy statute, but that's not this bill. So this bill is not the first in its nation. We would actually be the third that's actually using truancy law as an enforcement mechanism. There is nothing in this bill that states that a truancy officer would separate a child from a parent and a conversation. There's nothing in the bill that says that. So I want to be clear that the reason that language was added was at the request of homeschool families that I met with, as well as the Senate. So they felt it was important for people to meet kids so that kids would be able to tell how their experiences were going. And again, this was also at the request. I've been meeting with homeschool families, not just my constituents, frankly, more than, no, sir. Can you please turn your microphone? You'll get a chance to answer questions, but it's my turn. Thank you. So I want to be clear that I have spent a great deal of time, as represented, as chair has as well, meeting with homeschool families across the state of Illinois. And so this was actually a request that they made to have their children be able to talk about what they've learned, which I thought was a really interesting thing, because when you're doing it well and you're doing it in a way that kids are having these different kinds of experiences, our students, our kids want to tell you about it. I have a scarf in my office that a child made for me and talked about how they made, that was done in a way that was part of their math and grids and learning. And I thought, wow, what an interesting way to do that. So again, that was a change that was at the request of the Senate and homeschool families. The comment about, on page 3, about changing the definition of homeschool, that's incorrect. That was actually language that was from the original bill. It's also that we would be required to treat them as a private school, and so it's a little bit different there. And again, I think some of the language was about not full-time. The goal is to make sure we have an opportunity to see the kids, that we have an opportunity to the children who are being isolated, not the kids who are part of co-ops, not the kids who are part of other organizations where they're maybe in front of another mandated reporter, or in co-ops and different organizations where other adults are seeing kids. We're talking about kids who are being isolated. That kid like Zion who was pulled from school and nobody saw him. Maybe that young man from Connecticut who was pulled from school in 4th grade, never to be seen or heard from again until he had to set his house on fire. That's who we're talking about, the children who are isolated. I want to make sure, again, the record is clear. Mr. Butler used the word school district quite a bit, and school district only applies to Chicago Public Schools. They are their own school district. They are their own truancy officer. This does not apply to our regular home school, those of us who live outside of Chicago. Those are school districts. Intermediate Service Center are Cook County schools that are not in CPS. Again, just let's make sure we have the record clear. I know that there were fiscal notes that were put on this bill and no fiscal impact, so I love that. And the assumption that there's a ballooning of a caseload to DCFS, I'm trying to figure out how to respond to that in the nicest way, because I guess the assumption is we're trying to make sure that these are the kids that are being watched out and don't fall through the crack. So if we have an increase in investigation because our bill made sure a child didn't fall through the cracks, well, Lord help us. It looks like we did our job, everyone. So wow, I'm glad you support making sure that that happens. 38 states, everyone, 38 states have a declaration form. There is nothing in this bill that makes it more onerous than in the 38 states that are doing this. That is a fact. I'm ready for questions, Madam Chair.
Okay. I'd like to request that the state board approach the table so that we can just explain on the record the differentiation between homeschools, co-ops, and private schools. I know there was some question, and I just like clarity. Thank you.
Good morning, Dana Stoger from the State Board of Education. If a student is in a home and receiving education outside of their own home, that would be considered a private school and they would need to be registered.
Okay. Moving on, questions from our committee. Representative Johnson, you were up first.
First, I do want to thank the pastor and his wife the past couple weeks for your testimony. I cannot wait to see what great things your 6 kids are going to accomplish in life. I'm looking forward to that. I spoke a couple weeks ago, and I didn't in Rock Island, and since I asked the sponsor a question a couple weeks ago, I will tell you, we will all take images of her, and forever etched within me will be this vision of this little boy that was found months later in his Spider-Man pajamas dead. I will never, ever get that out of my mind. I will not. And I asked, or the fact that the mother basically said, the reason no one's going to know what happened here, I'm just going to tell them I'm homeschooling my child. And that is something that is really problematic for me as I continue to go back and forth on this bill. But, you know, I'm proud to serve. There's 118 of us in this chamber, and we all come from different places. And we've all gotten a lot of mail. I have gotten, I would say, a lot more in support of this legislation as opposed to early on as we get going. But I think we're all going to pick one particular issue that's important to me. And I will tell you, I'm a very, very proud girl dad. And the things, the letters that have the most impact on me are when I hear from young ladies now who were homeschooled who say, you know, when I was growing up, I was told that I was going to be educated. I could not be an engineer. I could not go into this field or this field. My parents told me that was unattainable for me. Is there anything in this bill that, because I believe that every child should reach their fullest potential, and I don't think anybody, including parents, should ever be able to mute that voice or mute that potential. Is there anything in this legislation that would create an environment in which these children that would happen to be in that environment can reach their fullest potential, such as pertaining to curriculum? Thank you.
Well, Representative, I mean, yes, there's mandated subjects that have to be taught. That is already currently in statute, and that's what it is. There's no curriculum requirement that has to, you know, they don't have to take the curriculum from the public schools if that's what you're asking. There's nothing in the bill that requires it, but it does require that subjects, language arts, math, physical science, behavioral science, or I'm sorry, not behavioral science, excuse me, physical science, biological science, social science, fine arts, physical development, and health. All of those subjects would have to be taught.
So respectfully, am I able to speak at this time?
So, Mr. Butler, I'm going to allow you to make a statement, but I do want to point out that you were allowed to make a statement in opposition to the bill, and that you have done that. It is not your role then to act as the opponent at large to speak to any contradictory point that is made up. So you may make your statement.
Work is what I think about, and I would ask this committee to think about it. And this, there's nothing in the bill that says separate a child, but there's nothing in the bill that says that you can't. And while some of us may be able to have a lot of trust in the bureaucrats who are going to administer this if it becomes the law, I just simply do not live in a world where that is a convenience that we have. This would need to be extremely precise. If we cannot assume, based on the way that laws have been enforced, all
Education rights and educational equivalency. I would like to say that CRHE feels that this bill provides tools that are necessary to help young girls who are in this situation. It is very common that a grandparent, an aunt or uncle, or an older sibling who is now an adult and has left the home is aware that a minor girl inside that home is receiving an education that is not equivalent to what the boys in the home would receive or what boys would receive in a public school setting. We have had many situations where that concerned family member or family friend reaches out to the authorities and says, this girl is not receiving any math education or any science education. The only thing that she's allowed to do is learn homemaking. And because the authorities do not have the tools to respond to that situation, they do not have what this bill lays out, which is how a truancy officer would investigate a case of educational neglect and make sure that the students were receiving an education equivalent to what they would receive in the public school. Because they don't have that tool set, nothing happens. That has happened so many times, I have lost track of the number of older siblings and concerned family members and concerned family friends who have spoken to me, the parents, to educate the girl, and they can't do anything about it because the authorities believe their hands are tied. The authorities will no longer believe their hands are tied after HB 2827 is passed because there will be a mechanism for investigating educational neglect. And a girl who is just not receiving any higher math education whatsoever through high school, that girl is going to be deemed educationally neglected under this provision because she's not receiving any math education through grades 9 through 12, which is the concerns that we run into consistently. So for that reason, we do think that HB 2827 responds to your concerns.
Thank you. Mr. Johnson, are you finished?
I am. Thank you very much. Once again, thank you to everyone. But I will forever fight for Zion and for those little girls I'm talking about. I just want to make that clear. Thank you.
Representative Yang-Rohr, you were next.
Thank you, Representative Costa-Howard. I just want to first thank you for all the work that you've put into this. I know it has taken a lot of time and has taken many meetings with your constituents, with probably constituents from around our constituents and from around the state. I want to also make sure to thank my constituents who have come to me to talk with me about how this bill would affect them, families in my district.